Today I'm going to talk about the IP protection strategy and practice in China. I'm Chen from Dazn Shira and Associates, leading business advisory department and have rich experience in helping foreign investors navigate the complex landscape of legal advisory services in China. So let's start with a brief introduction to our company, Dazn Shira Associates. Founded in 1992, we have grown into a group of companies with more than 35 offices located across 15 countries throughout the whole Asia. We support clients from our offices strategically located throughout China, Hong Kong, India, Singapore, Vietnam, etc. And our team of over 600 service professionals provide expertise in legal, tax, accounting, audit, HR, and IT. Our services are tailored to help executives and decision makers managing the legal financial issues that international firms face with market entry and operations in Asia's unique market and jurisdictions. Moving forward, I'm going to take a few minutes to firstly review the IP protection landscape in China. Over the past few years, China has made significant progress in strengthening its intellectual property rights protection. In recent 2 years, China experienced notable activities in patent registration. By looking at the table on the left, among the enforced patents till 2023, utility model is significantly higher than the other two categories, indicating a strong focus on practical applications and improvements in technology. And numbers of the granted patent in the same year shows a similar trend, with utility model leading, followed by invention and designs. For trademarks, there were 46 million trademarks in force up till 2023, and over 4 million just granted in that same year. And the data overall here underscores China's commitment to fostering innovation and protecting intellectual property rights, which is crucial for encouraging creativity and economic development. And now let's dive into the main topic, IP protection in China. When it comes to protecting your IP in China, it's essential to understand the types of IP that are protected by law and specific characteristics of each. In China, we protect copyright, trademark, patent, geographical indications, and trade secrets. I'll just focus on trademark and patent in this slide. A trademark is a sign that identifies goods or services and distinguishes them from others in the market. In China, the trademark system follows a first-to-file principle, meaning that the first applicant to register a trademark gets the protection. And patents are also a crucial form of IP. There are three main types of patent here in China. The first one is invention. Invention means that something protects new technology solutions and have a protection period of 20 years. We also have utility model that covers new technical solutions related to shapes, structure, or combination of products with a protection period of 10 years. And the last one is design patents, protects the appearance of product with a protection period of 15 years. Invention offers the broadest scope of protection, and utility model only protects products that have a specific shape, structure, or their combination. And design patent mainly focus on protecting the appearance of industrial products. And next, I want to talk about patent registration. In China, we have patent law that outlines the basic framework and regulations. There are multiple routes to register a patent here. You can either submit an application directly to China Patent Office or use Patent Cooperation Treaty to file an international application that can later enter national phase in China. The examination process varies depending on the type of patent. For invention, it requires both preliminary and substantive examinations. The substantive examination is a thorough review of the invention's novelty, utility, and inventiveness. The overall examination period of invention may take up to 3 years, and the average period in last year is shortened to 15 months. For utility model and design, these do not need to undergo substantive examination, so the process is generally more straightforward, faster, and focuses mainly on the formal requirements. I like to share a case here for you to better understanding the importance of patent registration. So here we have a foreign company known for developing rapid detection technologies for bacteria. This company holds 2 invention patents in China. And however, one local company here in Guangzhou was accused of producing and selling an IVD product that fell within the scope of production of this foreign company. Although local company argues that their products were customized with special formulated and improved raw materials, the court still ruled in favor of the foreign company and further ordered the local company to cease manufacturing, promotion, and sale, and also need to compensate for the foreign company's economic loss totaling up to 2 million RMB. So this case serves as a reminder of the importance of respecting intellectual property rights, the necessity of early registration, and potential consequences of infringement in a highly competitive and regulated market. And next, I want to talk about trademark registration. Similar to patent registration, there are 2 ways to register a trademark in China. One is direct application in China by submitting your application to National Trademark Office, and the other one is through Madrid International Application with WIPO. International application means you need to file the application and designate China as one of the countries for protection. So I won't spend too much details here, but I do want to give you some, I do hope you can pay attention here for the broad coverage, because when applying for trademark, please consider registering in multiple classes. These will help prevent others from leveraging the company's trademark reputation to free ride on different goods and services. For instance, IVD companies, in addition to apply under the category of medical devices, you may also consider to register in related categories such as chemical reagents and biotechnology. Also, if your trademark registration faces challenges, you have several remedies available. The first one is opposition. You can file an opposition against an existing trademark application that you believe infringes on your rights. And the second one is non-use cancellation. If a trademark has not been used for a certain period of time, typically 3 years, it can be cancelled due to non-use. And the final remedy is called invalidation. A registered trademark can be invalidated if it is found to violate certain provisions of trademark law, such as being misleading or against public interest. Next, I want to talk about trade secrets. Trade secrets may be overlooked by certain companies. Unlike patents and trademarks, China does not have a specific law regulating trade secrets. Instead, trade secrets are defined by anti-unfair competition law. Trade secrets is more suitable for protecting commercial information and technology that cannot be disclosed, such as company strategies, customer information, etc. To count as trade secret, the technical and operational information shall be commercially valuable, not disclosed to public, and guarded by confidentiality measures. I'll share a case here to give you all a better understanding. Company A, which is the plaintiff of our case, is a diagnostic technology company based in Shanghai, and one of its former employees disclosed the trade secrets to Company B after joining Company B. And later, Company B relied on such trade secrets and manufactured an IVD reagent kit for sale. Company A then filed the case to court, and this case was finally brought to the highest Supreme Court. Supreme Court, after examination, held that the Company A could reasonably extract technology solutions from its internal process procedures and quality control standards, which are not known to public. As long as these solutions are not generally known or easily obtainable by the relevant public, they can be protected as trade secrets. So this case reinforces the judicial protection of trade secrets here in China and sends a strong message that courts will safeguard intellectual property rights, even in very complex cases. After having a general understanding of what can be protected as intellectual property rights in China, I'll introduce potential solutions for intellectual property rights infringement. Let's start with an overview of the IP cases handled in year 2023. So the number here on the upper left is the total cases accepted by court nationwide in 2023, among which nearly 8,000 cases involving foreign parties. And also in that same year, a significant over 300 cases applied punitive damage with a total awarded amount reaching historical high, that is over 1 billion RMB. So these statistics indicate that despite your best effort, IP infringement will still occur. And when it does, there are several solutions you can pursue. The first one is administrative solutions. Under these solutions, the companies can file complaints with Administration for Market Regulation, which is shortened as AMR, and AMR can investigate the case and impose fines on infringers. And the second one is customs protection. Despite you can file your patent or trademark application, you can also register your IP with Chinese customs, and this will help you to prevent infringing goods from entering or leaving the country. And the second option is litigation. You can file civil cases and claim for damages, including statutory damages and in certain cases, punitive damage. And in several cases, someone may also face criminal charges, including imprisonment. And also there are alternative resolutions such as mediation and arbitration, which may be less time consuming than litigation. So the aforementioned remedies are not mutually exclusive and can be combined according to the actual cases to maximize the protection of the company's interest. And by utilizing a combination of different remedies, the company can secure comprehensive intellectual property protection that covers various aspects of its innovation. And lastly, I want to talk about some key takeaways for IVD industry. IVD industry relies heavily on innovation and technology, making IP protection even more critical. Companies in this sector should be proactive in registering their IPs. In the fast-paced industry, early planning is not just an advantage, it's a necessity. And by starting early, you ensure that your innovations are protected from the outside. And also remember, comprehensive registration is not just about patents, it's also about your trademarks, copyrights, and even domain names. So the comprehensive registration approach will cover all bases. Also, don't wait for issues to arise. You shall stay ahead by monitoring potential threats and being ready to act swiftly. So in this case, you shall monitor the market, conduct regular audits, and also keep an eye on your competitors. Next, let's talk about trade secrets, an often overlooked aspect of IP protection. Your trade secrets are your silent assets. Implementing an overall confidentiality system is crucial to keep them under wraps. And also, as technology evolves, your means of protections shall be enhanced as well. And leveraging advanced technical solutions can provide an extra layer of security. And lastly, the role of your employees cannot be overstated. They are the frontline defenders of your IP. So you shall educate your team on IP protection and also put some restrictive clauses in the labor contract or the internal staff handbooks so as to let the employees understand the value of the IP and also their role in safeguarding it. So in conclusion, protecting IP in China is essential for businesses to thrive and maintain their competitive edge. By understanding the legal framework, taking proactive measures, and seeking professional advice, companies can safeguard their valuable intellectual assets. And that's all for my presentation. If you have any questions, you can follow us on WeChat, and I also put my personal WeChat here in case you have special questions you want to share after this webinar.
Thank you so much, Chen Chen. I'm very